Hi, my name is attorney Jordan Phelps. I'm a partner here at Ryder and Phelps, located mainly in Westford, Massachusetts. Our practice primarily revolves around domestic relations, including complaints for divorce, complaints for paternity, complaints for contempt, complaints for modification, and things such as that. I've been practicing primarily in domestic relations in the Middlesex Prorated Family Court for about 10 years now. I graduated from Suffolk University Law School back in 2012, and again I have been practicing specifically in the Prorated Family Court here in Middlesex County, Essex County, and Norfolk County since that time. So here in Massachusetts we have the Child Support Guidelines, which helps parties and attorneys determine what the proper amount of child support for their child or children would be. So there's a text of the Child Support Guidelines that is about 26 pages in length, and then there's actually a Child Support Guideline worksheet which will generate the amount of the child support, and that's a 3-page Excel document. Essentially, the guideline worksheet looks at the party's parenting plan. It looks at the age of the children and also the gross income of the parties, with certain deductions or credits for medical insurance, dental insurance, vision insurance, and child care costs. And then it generates a figure which is presumed to be the correct amount of child support. There are grounds to deviate from the guidelines, and those are listed in the text of the guidelines. But again, there's a presumption that figure that's calculated by the Child Support Guideline worksheet is correct. So in order to obtain a child support order, you would need to file a motion with the Prorated Family Court. If you were married to the other parent of your child, you would file a complaint for divorce. If you were not married, then you would file either a complaint for custody support visitation if you were named as the parent on the birth certificate, or you would file a complaint to establish paternity if you were not named on the birth certificate. But regardless of the underlying motion, you would file a motion for temporary orders. In Massachusetts, there's a track assignment of 14 months in a divorce action, so most people cannot wait 14 months. So you could file a motion with the court. You would generally get a hearing date in or about 2 to 3 months, and you would provide the court at that time an updated financial statement which lists your income, assets, liabilities, and a child support guideline worksheet. You would go in front of the judge and you would argue your position as to the amount of child support that you should receive. And again, there's going to be a rebuttable presumption that the child support guideline worksheet figure is the correct figure as to the support that you should receive. In certain cases, specifically paternity cases, you may be entitled to a retroactive award of child support back to as far as the child's birth. And that depends upon many factors, depending upon where the parties lived and the level of support from the other parent. But that's certainly an option. It's written right into the statute under Mass General Laws 209C. In a complaint for divorce action, generally you're not going to be entitled to past support, and then it would be incumbent upon you to go file the complaint for divorce, file a motion, and ask the court to enter a prospective order of child support from that date moving forward. So alimony is calculated in Massachusetts according to the Alimony Reform Act. The Alimony Reform Act provides definitions as to the length of marriage, how that's calculated, the various types of alimony, the amount of alimony, and the length of time in which someone is potentially entitled to alimony. So if you look at the statute is very helpful in giving indication as to what the court can potentially do. In an alimony case, presently, due to the change of the tax codes, the specific amounts of alimony that we're seeing the judges enter is different, and the statute currently states 35% the difference between the party's income or the need of the recipient, but that was passed at a time where there was a tax effect to alimony. There's no longer a tax effect to alimony, so generally across the board what we're seeing is that the courts are entering a smaller percentage of the delta between the parties. So it's essentially 20 to 25% to take into consideration. There's no longer a tax effect of the alimony to the payor or to the payee. So I hope that was helpful. Thank you for taking your time to view our website. Thank you for watching the videos. And if you have any questions, we're here in Westford and we're happy to help you with any of your family law needs. Thanks.